How many times in the last 2 weeks have you heard the word suppressor? Even as a Californian, where they are banned, suppressors definitely seem to be at the top of everybody's list this year. We have lawsuits in California, we have lawsuits outside of California, and we have federal legislation that's going through the Senate right now. So let's go ahead and tie a nice bow on this. This is everything you need to know as a Californian on suppressors. Let's talk about it. Hey everybody, welcome back to the channel today. That is right, we have suppressors on the mind with so many different things going on, lawsuits across the country, federal legislation, and lawsuits here in the state of California. I thought it would be a good idea to just do a video and kind of try and tie all of them together so that we as Californians know what to expect and what to watch out for looking forward on this suppressor issue. And of course, to walk us through that today, we have brought back the CRPA President. That is Chuck Michel. Chuck, thanks for being with us today.
Always a pleasure, guys. Thanks for having me.
Yeah, absolutely. And guys, before we get into this today, please be sure to like, share, and subscribe to these videos. It really helps work the algorithms to get them out as far and wide as possible. And as we continue on this trend of moving the ball forward for the Second Amendment community in California here, it really does go a long way. And hey, if you're out of state and you just want to have an impact at ground zero here in California, where a lot of these bad laws cut their teeth, make sure that they don't get to states, other states in the union, you can always join CRPA and support us that way. Of course, sharing the video goes a long way as well, but you can find that link in the description below. It really goes a long way with the litigative and legislative efforts that we have. So Chuck, I feel like everywhere you look, everybody's talking about suppressors right now. They're always... or at least the videos that we've put out have been pretty specific to one thing, but I kind of wanted to wrap it all up today just so that we can understand all of the different elements that are going on and what to watch out for moving forward. In doing that, I thought we could start with kind of what's furthest away. We got a lawsuit. It's the Peterson lawsuit out of Louisiana. Where that had some very recent consequences in it. Could you go ahead and just summarize this lawsuit and what it's brought us to here today and what we're looking at over there in Louisiana?
Sure. Well, let me give you a little background first. You know, we've got suppressors. Things are happening with suppressors everywhere. The federal government, the House, just voted to take suppressors out of the National Firearms Act, which is huge. Now the Senate's got to go along with it. We'll see what happens. There was some debate about whether or not to just lower the tax to zero or to actually get rid of the registration requirement. Lowering the tax to zero is not the goal here. We want to get suppressors out of the registration requirement in the National Firearms Act entirely. And interestingly enough, when that National Firearms Act law was passed back in the 1930s, the position of the United States was that you couldn't criminalize their possession because it was protected by the Second Amendment. So they made it a tax instead. So they want to take that out, that registration requirement out. That's a debate that's going on in Washington, D.C. Meantime, in California, we have a ban on suppressors under state law. And we're trying to get rid of that in a case that the CRPA is involved in called the Sanchez case, which is in the Court of Appeals right now. The CRPA is actually representing Mr. Sanchez to try and strike down the California suppressor law. In the meantime, the analysis that's being done to determine whether or not a suppressor is or is not protected by the Second Amendment goes back to the Bruen analysis. Remember, there's a fundamental question, which is whether or not the hardware or the conduct that's being regulated is covered by the Second Amendment and the language, the right to keep and bear arms. It's not just about a hardware question. All kinds of conduct, repairing a firearm, going into the range, hunting, using it to defend yourself, all of those ancillary kind of things that go along with simply possessing, holding a firearm in your hand, are protected by the Second Amendment too. Now, the courts have been going back and forth, and this ties back into our Duncan case on magazines that can hold over 10 rounds, some of the courts that want to not get into the second phase of the Bruen analysis, which is whether or not there's a historical law that's similar enough to the current day law that it would indicate that the founding fathers would have tolerated the modern day law because they tolerated something very similar back in the 1790s. So what happened in the Peterson case, long way around the block to get to that, is that the United States government, Mr. Peterson was convicted of possessing an unregistered suppressor. The United States government initially took the position that a suppressor was not an arm, it was an accessory. And that's what the court in the Duncan case did too. The en banc panel in the Duncan case said that a magazine, a 10-round plus magazine, is not an arm, so it's not protected by the Second Amendment. This is a dodge that courts are using to not have to get to that second step where the burden is on the government to prove that there was some historical analog law that would indicate that the modern day law is tolerable. So the most recent development in the Peterson case in the Fifth Circuit Court of Appeals, in the United States versus Peterson, is that the United States Supreme Court filed a motion for leave to file a supplemental brief. And in that supplemental brief, they admitted that suppressors are not accessories. They are a firearm or part of a firearm that is protected by the Second Amendment. And so the Second Amendment argument needs to shift to the second phase, which is whether or not there's a fundamental right. So that's where we're at with that case.
So that's kind of interesting. So, I mean, first of all, you have a case where the government is going up against a citizen. That citizen brings complaints. That's fine. What exactly happens in a lawsuit where the government changes its position? You know, we got this bad ruling out of the Fifth Circuit Court that basically classified a suppressor as an accessory. Is there any retroactive function of the court if the government changes its mind and switches position? How does that work?
Well, they let the court know that their position has been changed and the court needs to redo its analysis. And the court will, because the government has now taken the position, and this is the Fifth Circuit, very generally a friendly circuit. They should now acknowledge that suppressors are a firearm or a component that is protected by the Second Amendment. And so this is a huge admission. This is a huge concession by the United States government that will be used in every suppressor case. Remember, we've been working with the Suppressor Association for over a year now, trying to come up with a national strategy to first knock out the National Firearms Act suppressor ban, and then go state by state that have the state laws and knock those out. And so now we're going to, in our Sanchez case, we will file a notice that the government has taken this position. We'll file, it's called a 28J letter as a supplemental authority. Actually, I think we still have a reply brief that we get to file. So the point is, we will make this point to the Ninth Circuit in the Sanchez case in challenging the California law. And it's a pretty big admission because it gets you out of that first step on whether or not the Second Amendment language is implicated and over to that second, it's not really two steps. The first is just a question. The second is the test. The test is whether or not there's the historical analog law, which is similar enough to the modern law to indicate that it would be tolerated. And so and then that's the government's burden. So if the Ninth Circuit does what it should do and accept the United States government's position as the law, it's now going to have to do an analysis of whether or not there's a historical analog that justifies the modern day law. And this applies, the significance of this is not just suppressors. Remember, certain courts have said that fully automatic firearms are not arms that are covered by the Second Amendment. And the CRPA did an amicus brief in one of those cases. I think that's
the Kitson case, right?
Kitson case up in Oregon, where the court applied the analysis the wrong way. This is why the central fight that we're having in every case across the country is how to properly apply the Bruen analysis. That's why it's so important that the court takes Snopes or one of these other cases that are up in front of the United States Supreme Court now. And unfortunately, they postponed the hearing on whether or not to take Snope again this morning. Now it's postponed for another week. So we're waiting on pins and needles to hear whether or not the Supreme Court will take Snopes. They have to take something and set the record straight on what is, so the courts can't keep dodging the true Second Amendment question, which is whether or not the founders ever would have tolerated the type of modern day law that's being challenged under the Second Amendment today by CRPA or others.
And I did notice that. I came in today and I looked at the order list from the Supreme Court, noticed that Snope as well as Ocean State Tactical were not on it. So continue to look forward to those. And I guess we're going to also have to do a video on these amicus briefs that we're filing here as well, because I know we have, I think, 3 different cases being heard in oral arguments at the Ninth Circuit in the month of June. So definitely going to be a busy month of June for the Second Amendment.
Folks can take a look at the Second Amendment Law Center website, and all those cases, this two ALC filed briefs, and there's a little summary of each of those cases on that website, and take a look and support the Second Amendment Law Center and the CRPA if you got a few shekels, because we're doing some great work, some historical work. We're fighting for Second Amendment freedoms for ourselves and our children, and it's a historic time and a historic fight. And throw a little money in, and you'll be a part of history.
Yeah, couldn't agree more. But that effectively is one piece of the puzzle. So we have this lawsuit that's happening in Louisiana where the Fifth Circuit essentially classified suppressors as accessories, not firearms, which has allowed them to enforce a ban, which one individual was arrested for and is now suing the government. They didn't give us the decision that we wanted, but what that effectively made the federal Department of Justice do is change their position and state that suppressors are firearms. So the Fifth Circuit is going to have to reconsider that as a court. Meanwhile, let's bring it back to the Sanchez case here. I know that you mentioned the federal legislation. I want to touch on that in just a minute, but the Sanchez case here in California, we're effectively dealing with the same thing. There's a ban on suppressors here. So can you, for those who haven't been following along, can you go ahead and summarize the Sanchez case for us really quick? What's the origin here? How did CRPA get involved? And even if they're kind of the same arguments as the Peterson case in Louisiana, what are the arguments here in California?
Well, procedurally, the Sanchez case is interesting. Mr. Sanchez filed a lawsuit pro per, in other words, without a lawyer representing himself. He lost in the district court and then appealed it to the Ninth Circuit. He got it right up to that point. I mean, obviously, he's not a lawyer, so this is the work product needed improvement, and the Ninth Circuit recognized that, and so they put out a call to law firms to submit briefs because they weren't satisfied with Mr. Sanchez's brief. So CRPA and Michel and Associates, my law firm, and Cooper and Kirk, another law firm, we all jumped on board and are helping him out. We're actually representing Mr. Sanchez as opposed to the usual role of an amicus, a friend of the court brief. And so we filed our brief arguing again that suppressors are protected hardware, protected under the Second Amendment, and that there is no historical law that would justify a ban on suppressors or a tax on them for that matter. And if you remember, I mean, there's a lot of confusion out there. You know, they demonize suppressors, call them silencers. They don't silence anything. They protect your hearing. People that live near shooting ranges love them because they keep the noise down. That typically ranges have to deal with complaining neighbors all the time. But the big thing is they protect your hearing. And as any shooter that has to ask you to repeat yourself several times demonstrates, going to the range a lot can damage your hearing a lot. So these are important tools, important health and safety tools that folks need to get access to. That's not to say that, the classic silencer that you might think of that you see in the movies, it's not the same thing. A suppressor is a very important part of exercising your right to keep and bear arms. And so having that option, having that tool available is part of the Second Amendment. So it's very important to get these things available and make them normalize them, let people know they're nothing to be afraid of, and make them available for folks to use.
You said that the Ninth Circuit put something out to law firms saying, "Hey, if you'd like to submit anything, you can." I'm kind of curious. Is that like a general practice of the court when they see something like that? Is somebody doing the Second Amendment community a favor?
They do it not in the Second Amendment context. If there's a pro per up there who's having a hard time, often they will ask a lawyer to volunteer to step in and help them out. And not often. I mean, it doesn't happen that much, but it does happen occasionally. It's not unheard of. And but in the Second Amendment context, it's even rarer. I mean, it usually happens when some guy was convicted of something and he's trying to appeal his conviction and he couldn't afford a lawyer, and he's got an issue that the Ninth Circuit is interested in, and they want it actually properly briefed. So they put out a call and ask for lawyers to help out that pro per person that's representing himself.
Well, yeah, something definitely to jump on, and we did so quickly. So definitely good on that. This is a little bit of a tangent. I do want to stick on the suppressor, but I'm also kind of curious about this. If the Sanchez lawsuit is successful here in California, does it potentially lead to a lawsuit on threaded barrel laws? The most common way, unless I'm sincerely mistaken, for suppressors to be attached to firearms is with a threaded barrel. I know that there are other ways that people can take advantage of. Is that something that could be end up being down the pipeline here as a result of legalizing suppressors in California?
Yes, because a threaded barrel is one of the features that can turn a firearm into a quote unquote assault weapon in a combination with certain other features. So yeah, if you can't have a threaded barrel because having a threaded barrel makes your firearm an assault weapon, then there's a whole nother lawsuit that needs to be brought to challenge the ban on threaded barrels. Now, it's not a total ban because you can register, but you can't acquire new ones. So it gets into the whole assault weapon argument, which is also being litigated right now in the Ninth Circuit in the Rupp case and the Miller case. But it's another component of that that's going to have to be dealt with if we're successful in striking down the California suppressor law.
Well, it seems like things are definitely possible when you got the federal government on your side. Speaking of which, you've got the case from Louisiana. You may have mentioned this. I guess let's just confirm it. Is that something that gets cited? The results of that case ends up having the Department of Justice come out and say, no, suppressors are firearms. So let's judge this that way. Does that end up getting cited in the Sanchez case and used here in California?
Absolutely. We're going to cite the brief. We're not going to wait for a ruling from the Fifth Circuit. That'll take a while. And our brief is due before then. We're going to cite the United States government's brief and send a copy of it into the Ninth Circuit.
So you've got all of this litigation sort of coming around, and then all the way up here at the head, you've got the federal government that is legislating on suppressors right now. I guess without going too deep into it myself, again, for those who haven't been following along, can you just describe the path for this suppressor legislation? I understand that it's passed the House. There are some complications in the House, whether we were going to pass it or not pass it or reduce the tax. What was the struggle there? What ended up actually getting passed, and what is the Senate talking about now?
Well, there's a bit of an argument about what happened in the House. Some folks were pointing fingers saying that some other companies, there's a big industry creating gun trusts and doing the paperwork to register a suppressor or a full auto or a short-barreled shotgun or rifle or any other weapon, all the things that the National Firearms Act regulates. There's companies out there that provide that service and charge a fee for it. And so if you take a suppressor, and there's a short barrel shotgun and short barrel rifle law right up behind it, the suppressor, taking the suppressors out of the NFA was in that big, beautiful bill that finally got through the House and is now over at the Senate for reconciliation. And so now who knows what's going to happen. The House and the Senate have to come up with a language of a bill that they agree on, and then that goes up to the president. And so there's still plenty of stuff that the Senate on the budget side that the Senate wants to change in that House version of the bill. I don't know what the Senate is going to do with the taking the suppressors out of the NFA portion of the House bill. That's all part of the reconciliation process where the House and the Senate version are put together and come into one version that gets sent to the president.
But currently, you do have the NFA where suppressors are regulated under the NFA. Anybody outside of states that already have suppressors banned, they have to register them. They have to pay a tax for them in order to possess them. The original legislation in the House of Representatives was to remove suppressors from being regulated by the NFA.
So the original legislation, I believe, was to just get rid of the tax. And then everybody protested that and said, no, we don't want to have to register them all. Take silencers out of the NFA entirely, which they finally did in the House bill.
And that is what ended up getting passed and now is on under reconciliation at the Senate?
Right. The Senate is now considering that. We'll see if that even becomes an issue with them, because there's so many bigger issues with Medicaid and the SALT taxes and SALT deductions and all the other issues that go along with the budget and trying to cut the deficit. I don't know how big of a fight they're going to have over what is really a sideshow in their view compared to the other things that they're fighting, over money.
But I guess bringing it back to California and bringing all of these things together, you've got the federal government making some admissions with this lawsuit in Louisiana. You have a fight here in the Ninth Circuit to legalize suppressors, and you potentially have legislation at the federal level that would remove the regulation from the NFA. I mean, are we? I'm not necessarily saying in the next week or even months, but is this a situation where a Californian can literally overnight go from no chance, you got suppressors that are banned in California, to not only being able to purchase them, but also not even seeing the federal regulation? I mean, is this a complete reversal that might take place in the next year or so?
It might, but it's not going to happen overnight. Now, if they pull the NFA registration requirement out of the NFA for suppressors, then you're going to be able to go into, not in California or Illinois or the states that have suppressor bans, but you'll be able to go into a gun store and buy one in other states.
Right.
And that's going to be a happy day.
So what is it that Californians need to watch for? And what is the progression? I guess as a final thought, what is the progression that you see happening with all of these things working sort of together in the same direction? What is it that Californians should be watching out for?
Well, if we get rid of the federal registration requirement, or even if we don't get rid of it, but we still pay the tax. Well, if we get rid of the federal registration requirement, then there's no federal law banning suppressor possession, but there's still state laws in certain states. So we've got to get rid of those. In the states that don't have state laws, if we get rid of the suppressor being covered by the NFA, then you'll be able to get one without having to do any paper. You won't have to do the usual onerous paperwork that you have to do now. But even if they just get rid of the tax and don't get rid of the registration, it'll be kind of the status quo. You just won't have to plunk down any money, $200 or whatever it is, to buy that suppressor. But you'll still have to do the paperwork, and that's the real headache, and that's the real obstacle to folks getting a suppressor in states that don't have a state law ban.
Well, right, the state law ban. So the Sanchez case really ends up being the key, right? I guess regardless of whether
they might not change the NFA. In which case,
right,
even if we win the Sanchez case, it would still be regulated under the federal law. But you'd at least be able to do the paperwork and register it and pay the tax and have it in California that way. But look, it's a there's a matrix here that's all these things working together in different ways, and it's difficult to see how it's going to ultimately play out. We just have to keep pushing to get rid of everything that we can get rid of.
Well, yeah, and I guess as a Californian and it already being banned here, when you're looking at the spectrum of outcomes, we're already at the bottom. Like it's already banned. We can't have them. I guess the best case scenario is you've got the federal government on board. It's removed from the NFA, and we get rid of the ban here in the state, so that we can, in an unregulated way, be able to purchase suppressors in California. If it lands somewhere in between, it's still a positive for Californians, but I guess the most immediate thing seems to be the Sanchez case, and that is what we're going to be paying attention to.
The only problem is that the Gavin Newsom and his anti-gun owner cronies in politicians in Sacramento will, even if the suppressor possession ban is struck down, they're still going to try and do something like make you register it. They're going to treat it like an assault weapon. They're going to make you register it. They're going to put a tax on it, an excise tax or whatever. They're going to make it as hard as they can for people to get it, but it's not going to be completely banned. And we will obviously fight any effort to restrict the right to get it and to put so much red tape on it. That's what the game is in Sacramento now. Whether it's CCWs where they try and delay it as long as they can, or charge you as much as they can to get one, or any of the other games that they're playing. If they can't outright ban it, they want to put as much red tape on it and as many costs on it as they can to discourage people from acquiring the firearms, the hardware that is protected by the Second Amendment. And from using it. This is part of the ban on the gun culture. They don't want to have gun ranges. They don't want to have gun stores. They want to restrict hunting. I mean, they're going at us from every angle because they want to eliminate gun owners as a political force, which is why folks need to join the CRPA, get their emails, and if you don't want to put your name on a list, then have Fido join the CRPA. We'll be happy to send the dog a magazine and just stay informed and register, get yourself engaged in the fight. I'm saying it's a historic time. Be a part of history by getting in the fight.
Yeah, and that constant pressure definitely makes the victories all that much more sweet. Chuck, I know you're a busy guy.
We are winning in Sacramento more than we ever had before. We've stopped a lot of things. They don't have the momentum that they used to have in Sacramento to pass every bad bill. So our lobbyists and GOC and even NRA up there, they are pushing stuff back, and it's the hot time of the season right now. So stay tuned to CRPA.org to find out day to day. Rick Travis is up there putting out notifications on the bills that are being fought and that we're winning against.
Absolutely, and there definitely will be more victories to come. Chuck, I know you're a busy guy. I appreciate you coming on and sharing with us, and looking forward to the next one as these cases come up and go. I appreciate the time.
My pleasure, guys.
Absolutely. And guys, one more time, please, if you haven't already, be sure to like, share, and subscribe to these videos. It's a great way for you to directly contribute to the litigative and legislative efforts to keep the Second Amendment ball rolling here in the state of California. Even if you're from out of state, go ahead and join. Get on the subscription list. This is ground zero, so definitely want to put a stop to these bad laws coming into effect for the state and for the nation. Thanks again, guys, and we'll see you on the next one.